This is KHOI 89.1 Story City Ames, and you're listening to I Am Able Iowa, where we discuss the ability and disability. I'm your host for today, Nancy Baker Curtis, school teacher, board president of the ARC of Iowa, and parent advocate. Today, we will be discussing the Attorney General's lawsuit to overturn the Rehabilitation Act of 1973, better known as Section 504. This lawsuit could have a massive impact on Iowans with disabilities. And we have a really great panel of guests today to talk about how this could potentially impact Iowans with disabilities. With us today, we have Emma, correct me if I'm wrong, Emma Bouza? Tell me I'm sorry, I said it wrong.
Bouza.
Emma Bouza, who is currently a paraeducator. She has recently received her special education teaching certificate, and she is also a parent advocate with children who utilize a 504. We have Carlyn Crowe, public policy manager from Iowa's Developmental Disabilities Council. Christy Hickman, who is an attorney with the Iowa State Educators Association, and Laura Belin, who is a reporter from Bleeding Heartland, who helped break this story. So just to start off today, I'd really like to kind of set the stage and just really have a foundational understanding of what this lawsuit is. So I'm going to go ahead and start with Laura. And Laura, would you mind just giving us a brief overview of this lawsuit? What exactly is being challenged and who is exactly behind all of this?
It's a lawsuit led by the state of Texas involving 17 Republican-controlled states, including Iowa. And one thing that's odd about it is it was filed last September, but Iowa's Attorney General's office didn't announce it. Usually, on a regular basis, the Attorney General is bragging about all the lawsuits against Biden administration policies and rules. But this one, I didn't hear anything about it until February 10th, which was 4.5 months after the lawsuit was filed. So what they are challenging is a rule that the Biden administration Department of Health and Human Services issued. It went into effect in the summer of 2024, and then the states sued in September in Texas. And the genesis of this rule was that during the COVID-19 pandemic, people realized that there was a lot of discrimination against people with disabilities in the healthcare system. There were a lot of access problems. And so the Biden administration decided to do a really comprehensive rewrite of this rule that's part of the Health and Human Services Department in how they interpret Section 504, which is a 50-year-old law, the Rehabilitation Act, but it applies broadly in many areas of government. So people think of it as a 504 plan in the education context, but it really applies across the federal government. So this lawsuit was not related to a Department of Education rule. It was related to a Health and Human Services rule that is hundreds of pages long, that has lots of specific examples of different types of discrimination against disabled people that would be unacceptable under the rule. So the kind of hook for the lawsuit is a statement from the preamble that was not actually part of the rule itself, but there's a long preamble in federal regulations that explains some of the things behind the rule. And in the preamble, there was a reference to whether transgender people might have a claim in some situations depending on the facts. Could they have a claim that they were discriminated against under Section 504? And the preamble said that the Department of Health and Human Services during the Biden administration agrees that depending on the facts of the case, this could be true. So that is the hook for the lawsuit. And in public statements, the Texas Attorney General, the Iowa Attorney General, and many other states have really focused on this transgender language that is actually not part of the rule itself. But the lawsuit goes much further than that. The lawsuit is trying to say that the application of Section 504, that it restricts the use of federal funds unless states follow these certain protections for people with disabilities, that application is unconstitutional. And if a court were to find in favor of that position that the states are taking, it could mean that just huge areas of federal policy could be overturned. So states would not have to enforce Section 504 with respect to healthcare services, people with disabilities, whether they are in institutions or whether they can receive community-based services or in the education context. Even though the lawsuit didn't originate with education, the Section 504, the way it's applied to federal funding for education, I mean, that could definitely be affected if these litigants are successful.
I mean, this just seems like a huge can of worms, right? And you're talking a lot about healthcare settings and education settings, but 504s also extend into the workplace, right? And include workplace accommodations. They include everything from wheelchair ramps to push button access on certain doors, right? Just making it easier for people to have access to places that receive federal funding. And really, Laura, you were the first person to break this story. Until you broke this story on February 11th in your e-newspaper, Bleeding Heartland, avid reader, love it. Really, nobody was talking about this case. From your perspective, what have you seen as like the public's reaction to learning about this?
Well, there had been a little coverage of the lawsuit in some other states and nationally when it was filed, but I don't think anyone else had reported on Iowa's involvement exactly. Now, there was some coverage the week, a few days before I published. There was a little bit of coverage about a protest that some parents led to the Iowa Attorney General's office trying to ask her about this lawsuit. But I was very fortunate that I learned about the lawsuit on the same day that the Attorney General was scheduled to come to the legislature to testify before an appropriations subcommittee. So I had a chance to ask her about it in the hallway afterwards. And the answers that she gave me weren't really accurate. And I thought, well, maybe she just wasn't familiar with the case I was asking about. But then a couple of days later, when the Attorney General's office released a statement on it that was just misstating the legal arguments of the lawsuit, I mean, then I felt like I really had an even more important story, because not only is Iowa part of this lawsuit that threatens the foundation of Section 504, but the Attorney General was just not being straight about how far-reaching these arguments are. As for the public reaction, there has just been huge interest in this issue because so many people depend on Section 504, as you say, for workplace accommodations, for guarantees against discrimination in many areas of life. And the parents, I really have to credit the parents whose kids were on 504 plans, the ones who went to the Attorney General's office, because they produced Facebook videos and Facebook posts that got a lot of play. But I mean, this post on my website, I've published probably about 100 different articles or commentaries this year by different authors, and this is the most viewed by far. It's one of the most shared posts I've ever written on Facebook. I talked with State Representative Josh Turek, who, of course, is very outspoken about these issues, being the only legislator who is permanently disabled. And he said that his Facebook posts and Instagram posts about this lawsuit were also the most viewed and the most shared things that he had ever had on this platform. So there's a tremendous amount of public interest in this case.
And we've seen this sort of public interest and outcrying come in a lot of different forms in our states, whether it was last year regarding AEA legislation and reorganization. So I'm not surprised to find out that this has been so popular. I know that we're talking a lot about what's happening here in Iowa. Do you know anything about the way other states have responded to this sort of public outcry and this lawsuit? Are there any notable supporters or opponents at the state and federal level?
Well, several other state attorney generals are taking the same position as Iowa's to try to argue that the case is really only about transgender language, that it's not threatening Section 504 as a whole. And there was a development, a legal development, since I published that original article. The states and the Trump administration filed what's called the Joint Status Report. And the lawsuit right now is on hold because the Trump administration is evaluating this rule and whether they even plan to enforce the rule or whether they would try to go through the long process of repealing the rule. So for right now, nothing is really happening going forward in the lawsuit, and it's not really clear where it's going. But the states and the Trump administration tried in that status report to say, we're not challenging Section 504, on its face. We're only challenging the way it has been applied. But according to the Disability Rights and Education Defense Fund, in their legal analysis, it's really the challenge is still very far reaching because Section 504 itself authorizes a few programs like Voc Rehab is one that people might be familiar with, but most of the federal funding that is subject to these Section 504 restrictions saying you can't discriminate against people with a disability, most of it comes from other authorizations. So the Health and Human Services, the Medicaid funding in the education sphere, the federal funding for education, none of that is directly coming through Section 504. So according to the Disability Rights and Education Defense Fund, the legal stance is really hardly changed at all. But the attorney generals, many of them are saying, we're not challenging 504, or in the case of Iowa's attorney general, she's even saying we're trying to protect these classroom accommodations by challenging the Biden administration's transgender policy, which is really not what the lawsuit is about.
So, what are the legal or political motivations that seem to be driving this? Is it just the transgender thing, or is it a larger systemic issue to try to remove the rights of people with disabilities?
I think that the transgender hook was a big one. I mean, many states have challenged various Biden administration policies related to that. But it looks like in the original lawsuit that was filed, one of the areas of this Health and Human Services Department rule that the states really didn't like was this, it's the legalese term is that people have to receive care in the most integrated setting, which means that when possible, they should be getting community-based services and not in institutions. And part of the genesis of that was because during the pandemic, they saw a lot of people were not able to get community-based services. Then they were having to go, some of the most disabled people were having to go into institutions where they had the highest infection rates and death rates from COVID-19. So that was not equitable. So the states are saying, this is unfair, this is going to be very expensive, and this is an overreach by the federal government to try to control our spending. So it's kind of the constitutional challenge relates to the spending clause of the U.S. Constitution. And this language about people receiving care in the most integrated setting. And by the way, that could also apply in the education context, that to say that students should get services in their regular classroom rather than having to be in a separate classroom, this language about an integrated setting. And the states really don't like that. So that, I think, is also part of the reason. But I think there's a trend in Republican controlled states that they really want the federal funding to continue, but without any of the strings attached. So they don't want the federal government saying, you have to provide this, that, or the other. They just want to be able to get the money.
So I know some things happened this week. I know Tuesday was a big day, and I know that there are some potential next steps. Can you just give us a brief update?
Well, the status update that was filed, the deadline for it was February 25th, but they actually filed it a few days earlier than that on the 19th. The status update said the states and the federal government, they basically clarified this is on hold. The Trump administration is still deciding what to do with the rule. And they're going to be filing these joint status updates about once a month. So it's really not clear what's going to happen with the lawsuit. I mean, one possibility is if the Trump administration basically agrees with the state's position that the rule is unconstitutional, maybe this whole application of Section 504 is unconstitutional. At that point, there might be other parties that would try to step in and what they call it is intervening in the lawsuit. It might be blue states, it might be disability advocacy organizations that would step in and try to defend this Biden administration rule. For now, the rule remains in effect. It has not been struck down by a court. It has not been stayed by the court. The Trump administration is trying to decide what to do. I mean, I think it's very clear the Trump administration is not going to enforce several of the aspects on the states, but the Trump administration hasn't formally taken a position on whether they want to amend this rule or repeal this rule. And that would be a long process. That's not something that happens in a few days or weeks.
And so the real world implications for this are just huge. I mean, you speak, Laura, and I'm thinking Individuals with Disability and Education Act. I'm thinking Americans with Disabilities Act. I'm thinking Olmstead Act. I'm thinking all of these other huge landmark legislative cases. So I want to focus on that real world impact piece. And I want to talk to Emma next because Emma works in a public school. She just completed her special education training. She is a paraeducator, and she is a parent who has a child who utilizes a 504. And so, Emma, as both a future special education teacher, as a paraeducator, as a parent, how do you think, or how would overturning section 504 impact your child or the children of the families that you work with in the school that you work in?
I think for families, it's going to remove essential protections for students with disabilities. It's going to leave a lot of those students without the accommodations they rely on to be successful at school. It's just going to take away the equal opportunities for those students with disabilities. And then for schools, I think the loss of Section 504 protections would place unnecessary pressure on teachers and administrators to find different ways to help provide for those students. Then you're looking at more confusion on how to figure that out, inconsistency, and potentially more legal challenges then too. So I think it just overall, if it was overturned, it's going to further isolate students with disabilities and create more inequities.
And I just think about all the kids who don't have 504s, but that have IEPs and utilize those same accommodations, right? I mean, these are two supports that are put in place to ensure equitable access to the same high quality, viable curriculum that typically developing children or children who do not have neurodiversities and disabilities need. I think about, I'm a high school, middle school, eighth, ninth grade Spanish teacher. And so I'm thinking extended time on the ACT, right? That's a 504. Utilizing a scribe, that's a 504. Needing to have the test read to you, that's a 504. And so my sirens are just like going off like crazy, right? Can you share with us specifically an example of how Section 504 has helped the students that you work with in the classroom or even your own child?
So my daughter has a 504, and in her 504, she has preferential seating, so she actually chooses to sit in the back of the room. But and then she also in her 504 has reminders to submit her work, which I know if you don't have executive function issues, that seems like a really silly accommodation, but she'll do all the work and then she'll forget to turn it in. So she needs those extra reminders. Um, I know for other students, they've got, like you said, extended time on tests, additional breaks, or access to assistive technology, just so they can be more successful students. Um, yeah, it's just another way to level the playing field for all students.
I so agree. In fact, I had a student who had a hearing loss in one ear, and we do listening activities in Spanish class, and so in the regular classroom where there's lots of papers rustling and pencils dropping, it was just like almost impossible to administer that listening test. And so his 504 accommodations allowed for that listening to occur in an alternative setting, right? What am I testing? Am I testing hearing or am I testing comprehension on what he heard in Spanish? And those were the questions as an educator, like I wrestled with. So I can see like so many examples of this, even in my own classroom.
Well, and I think Laura had mentioned something too about um, then also qualifying for voc rehab. So my daughter also has voc rehab now, and with voc rehab, that helped her to qualify for I can't think what it's called. It was like driving therapy, but it was just to help her work through the anxiety of driving. So without her 504, she wouldn't have qualified for any of that. And that was such a valuable service for her. And she drives independently, but yeah, she didn't have that typical teenage drive to hop in a car and just go. And all of this helped her be successful in that.
That's something that people don't think of. And you live in rural Iowa, correct?
Yeah.
So driving is like a major thing, right?
It's kind of important to be able to do. Yes.
Correct. It's not just the job coach and the job training that you need to go out and transition into being career ready. It's so many other things. Um, what challenges do parents already have and face in securing 504 accommodations for their kids, even with the current protections? Can you speak to that a little bit?
I think sometimes schools are even a little resistant to want to implement a 504. And also, I think there's a lack of clear understanding and consistency across school districts about who can qualify for those 504s. And I mean, I know in our district, there's probably a lot of parents that don't even realize their child would qualify to start that process. And so then they don't have the necessary documentations or evaluations completed. And then sometimes even when you do have the 504 and the accommodations in place, parents, myself included, still have to advocate to have those implemented correctly. I know this year my daughter's in a higher level math class and wasn't turning her work in. And at conferences, we kind of talked about it with the teacher. And he said, well, this is a higher level class. Those things don't apply here.
Actually, they do.
Actually, they do. But yeah, so I mean, even with everything in place, you're still advocating and it's still a process. So I can't imagine not having that in place and having nothing to help support our argument that no, you do actually in fact need to support her a little bit more.
Or I've even talked to parents who have kids with ADHD or executive functioning, and they say, well, teachers have so much on their plate. I don't want to make them have one more thing to manage. And being a parent advocate, having a child with disabilities, being a teacher and a teacher leader, I say, well, actually, technically, it's your legal right. And teachers can't recommend it to you. You have to bring it to them. And I just want you to think about this for the future. Maybe it's not impacting your child right in this minute, but in the future, should they require these accommodations, it will be harder to secure.
Well, and I've tried to frame it for my daughter too. It's not like, don't view it as you're getting all this extra help. It's assisting you to become the best version of yourself that you can be. And I think that's every student deserves that. So, yeah, I want her to have that frame of mind. I wish more educators had that frame of mind, and apparently our legislation had that mind too. But, yeah, it's about being the best and most successful student they can be.
And I'm assuming those long-term effects that you're seeing would be this lack of consistency, the lack of equitable access, a lack of that least restrictive environment, or the FAPE, right? The free appropriate public education.
Yes.
I mean, yes, there's just so many things. Okay, so we're going to transition now because I just have the best guest today, and I want to give every single one of you a minute to have your voice heard. I'm just so excited to have you all today. And today we also have Christy Hickman, who is an amazing attorney with the Iowa State Educators Association, and she's going to help us put this in the perspective of legal and public policy, right? So, Christy, from this legal perspective, what are the core arguments that are really being made? Like these challenges, when you dug into Becerra v. Texas, what did you walk away with?
So just generally, there are 4 counts for 4 claims of relief made by the 17 states, one of which is our state of Iowa. And the state seeks a permanent injunction, which means a permanent stop to the enforcement of the final rule from the Department of Health and Human Services. In addition, they request an injunction, the same sort of injunction, stopping of the enforcement of Section 504, without any of the whittling down or the as applied challenge, where they are suggesting it is only under certain circumstances that 504 is unconstitutional. Those claims are written very generally. As we have heard, as we have discussed already, the states attacked the discussion of gender dysphoria in the preamble of the final rule. The preamble is, of course, not enforceable law, like the rules themselves. Administrative rules are, just as much law as the ADA, which is a statute on the books of the U.S. government. While the preamble is not enforceable, the rules are, of course, the rules of this particular agency, as well as others, as well as ADA, are going to discuss the definition of a disability. So in this discussion in the preamble of gender dysphoria, really all the agency is saying is this is something that we have considered. We are aware of the litigation around this issue, and we acknowledge that in some cases gender dysphoria may meet that very specific definition of a disability. And there has been almost exclusive attention placed on that argument in this lawsuit. And quite frankly, there are some incredibly worrisome indications that that is not the only goal that they are trying to achieve, or that trans rights are the only impetus behind these claims. The complaint is pretty clear what their claims are, and the statements that we've heard from our own Attorney General, she's repeatedly stated that 504 protections are not the target. Parents can feel assured that their children aren't going to lose their 504 plans. But she says instead that it is the, quote, radical transgender mandate the federal government has imposed upon the states that is the target. So let's kind of walk through the different counts of relief that they are seeking, because I want the audience to note that our Attorney General's statements about what this litigation is about is completely inaccurate. And I don't know if that's intentional. I don't know if that is unintentional, but certainly, she has joined our state as a party. She has added her signature line to this litigation as, counsel in this action. So it is hard to believe that she would not understand some of the claims and how these claims would concern someone who either benefits from the protections of 504 or has a loved one that benefits from those protections. So under the first count, what the state requests is a ruling by the district court that the rule promulgated by the Department of Human Services, it exceeds their statutory authority and is unlawful, and as a result should be struck down. They claim that both the final rule and 504 itself violates the Administrative Procedure Act, and as a result, on that basis, is unlawful. In count one, they discuss the final rule's definition of disability. They talk in terms of gender dysphoria being added as a disability that is covered. That is somewhat of a mischaracterization of what the rule says, and it certainly mischaracterizes the force and effect of that discussion in the preamble, I would say. In addition to, challenging the addition of gender dysphoria into the array of disabilities that is covered, they also attack this integration mandate. And Laura talked a little bit about this, and just generally that mandate is that it is the goal of this law for people to receive the services that they need without bias, without discrimination within their own communities, and to avoid institutionalization. Okay, so they challenge that piece of the rule as well. In count 2, they claim that the final rule violates the Administrative Procedure Act. I think I said that earlier, and I kind of jumped around a little bit. Excuse me.
That's
but
all right.
Count 2 addresses, claims violation of the Administrative Procedure Act, which prohibits an agency from acting in a way, writing a rule, etc., that is, quote, arbitrary, capricious, or an abuse of discretion. And they claim that when the rule deemed gender dysphoria a disability, that the agency acted in this way, arbitrarily, capriciously, and it exercised an abuse of discretion. Now, in count 3 could not be any clearer. Count 3 challenges the constitutionality of Section 504. It does not, count 3 and the arguments made related to that claim for relief do not appear to attach only in the instant, in relation to gender dysphoria. It clearly, if granted by this court in the form and fashion that the 17 states have asked, a ruling would essentially strike down 504. That would potentially impact, the things we've already talked about: housing, medical care, education, transportation, all hard-fought, incredibly meaningful protections for people with disabilities that arguably can be costly and inconvenient for states to implement. All the same, it was always the intent of 504, as well as many of our other laws protecting, people with disabilities and assuring that they get to participate in their schools and their communities like everybody else. So count 3 is incredibly worrisome. Just going back to the denial of the Attorney General that this is anything more than just an attack on transgenderism, she clearly isn't acknowledging that this litigation asks the court to do a whole lot more. Count 4, they're claiming that the final rule extending the definition of a disability to include gender dysphoria by imposing the integration mandate and the at risk of institutionalization theory imposes new and onerous conditions on federal spending and violating the spending clause. So when we are talking, especially about these later counts, especially 3 and 4, this is very much a lawsuit not about LGBTQ rights, trans rights. It is very much about an effort to quell what, some red states believe is overreaching by the federal government. That's what's incredibly troublesome at this point about the claims that are being made and about in the media, what people are being told the claims actually are and what they aren't.
Christy, thank you so much for that extensive overview, because I really do think there is a lot of misinformation. And for our listeners that are just tuning in, you're listening to I Am Able Iowa, and we're discussing all things Section 504, Rehabilitation Act of 1973, and the Attorney General's lawsuit to overturn this historic and landmark disability legislation. We're talking to a great panel. And so we're just going to keep going and talking a little bit more, and any of you chime in here. I just can't even imagine if Section 504 were overturned. And I am just wondering, as I think, what other disability right laws, such as the ADA, Americans with Disabilities Act, or the Individuals with Disabilities in Education Act, um, what would be the prevention from stopping them from overturning these acts, right? These legislative mandates. And as I'm just wondering, do we have sufficient protections in place, or are there going to be gaps without the Rehabilitation Act of 1973? Laura, chime in. I'm dying to know.
So this joint status update that they filed this month, they tried to claim that they're not arguing that Section 504 itself is unconstitutional, but it's only unconstitutional in the way it's been applied to place restrictions on federal funding. And if the courts agreed with that kind of interpretation, it could imperil all kinds of federal spending. I mean, highway funds that are contingent on states having the drinking age being 21, or all different kinds of federal spending that for many decades has been contingent on states adopting certain types of policies. But the whole area of civil rights law could be affected because there's federal spending that is contingent on states making sure to enforce anti-discrimination protections that affect discrimination on the basis of race or sex. So it's not just discrimination on the basis of a disability. So it certainly could affect the ADA or anything in this field. But if the courts were to accept the logic of this argument, that it's unconstitutional for the federal government to say, we withhold the federal funding unless you do this, that could imperil all different kinds of policies at the state level.
Yeah, I'm thinking Title I or Title IX, right? And I think Title IX is one that we're all very familiar with, that idea that you need to have women and men's sports and athletic opportunities in schools, right? I mean, I just could see this being, do they call it a linchpin, or it's, to me, it's like we're pulling the pin on a grenade, and then we're just throwing it into disability protections, and we're just waiting to see what happens. I'm just, as a parent, as an educator, as somebody who have watched civil liberties be removed this week and horror, I'm afraid for what this means for the future of Iowans. How could this case impact not just education, and I think we've talked about this, but I'm thinking about just general accessibility policies as we know them. And again, anyone feel, go for it, Christy.
So what we know is they are challenging the lawfulness and the constitutionality of the federal rule itself. And those federal rules promulgated by the Department of Health and Human Services, there is a significant amount of that rule that specifically addresses accessibility in the context of health and human services. So certainly access to medical services, those rules would be stricken right off the bat. When you start thinking about the interwovenness of some of these protections, 504 is highly interwoven in, not necessarily in their language or their where they are located in the law. They're not in the same act, of course, but rules and case law share significant overlapping between those two laws. So, depending on, and this can't be predicted at this point, but depending on how a case like this would move forward, what arguments would be made, what arguments would be adopted by the court, it is hard to say, but incredibly, worrying that it would certainly negatively impact other civil rights laws, most especially disability rights laws. And that's just on top of just the general, the general fear that somehow, this isn't one of our American values anymore.
And that is just so disheartening to me as the child of disabled parents. My dad has a chronic healthcare disease, rheumatoid arthritis. He cared for my disabled mother for 6 years so that she could stay in her home. My own disabled child. It is just so disheartening to think that we are going back to pre-Capitol crawl days. And so as a parent, I need to know, what defenses do we have? What legal strategies can we consider to counter a lawsuit like this? What can parents do, and how can we mobilize and advocate for our loved ones with disabilities?
So I think at this point, Laura talked a little bit about the joint status report that was filed, and the court has essentially ordered the parties to check back in with the court on a regular basis, but everything is on hold. The defendants, the federal government, the Department of Health and Human Services, which now falls under the purview of the Trump administration, they are the defendants. They are also, ideologically probably aligned with the plaintiffs. So we may never see this case, even move completely through the district court. It's hard to say. But what I think someone that cares about these issues should do now is do things like watch your show, read the newspaper, please stay up to date, because things are going to change. And even if this lawsuit is dismissed or changed in some way, it still has the potential power of whittling down or narrowing the rights of the disabled community. We also have to watch what the federal government does with the rulemaking process. It is clear they don't like the preamble of these new rules implementing the Rehabilitation Act. So what part of the rules might they want to change? They would have to go through the same rulemaking process that the Department of Human Services did in 2003 and 2004. It would not happen overnight, and there would be an opportunity for public comment. So it's just remaining engaged and making sure that your state leaders and your federal leadership understand how 504, the Rehabilitation Act, the ADA, the IDEA impacts you and your loved ones and your communities. Because I think that to some degree this is... Go ahead.
I was just going to say, I think what you're saying is so spot on, and I think Carlyn can maybe speak to this too. We've seen through the mobilization of families and disability advocates that there are some states that have elected to kind of take a step back on their involvement with this case, right? I think maybe South Carolina or South Dakota received so much public feedback that they've kind of pulled back a little bit. So, and I think that the squeaky wheel gets the grease, right? I mean, when people come together and they mobilize and use their voice, that's how these things were enacted, and that's how we're going to protect these things, right? So what are the actions disability advocates and policy groups are taking in response to this lawsuit? And Carlyn, I would love to hear from you. Because you're DD Council, right? Iowa Developmental Disabilities Council. These are the self-advocates. These are the caregivers, right?
Yeah, and this is our job to help them know how to use their voice. And I want to thank the other panelists here who have provided their legal expertise, because this has really involved a lot of partnerships, because, I'm not a lawyer. And so it was very helpful to have Laura's opinion very early on in this, and to rely on other organizations like Disability Rights Iowa, who is following this and very closely, and also providing consultation and advice to us that we can then provide to advocates. But the interesting thing about this is that advocates jumped out early when the news kind of got out about what was going on with this lawsuit. And I think that a lot of it is because a lot of people know about Section 504 plans in schools. I don't think a lot of people know that Section 504 covers, non-discrimination when they go to the doctor, or certain aspects of healthcare that are really what this final rule that is being challenged somewhat was all about. So we're all learning, and we all need to kind of become legal experts because of this. And so educating advocates has been really interesting to see online. There's a lot of interest groups on Facebook, on other social sites that are everybody who has a stake in disability policy is talking about this. And actually,
go ahead. I'm sorry.
Well, I was going to say, actually, early on, because of some of the misinformation coming out of the Attorney General's office, people were like, "Oh, it's not a big deal. She's just honing in on one issue." And so countering that misinformation with, what the legal language is in the lawsuit was very important. And it's pretty straightforward, as Christy pointed out and Laura reported on early on. It's like, I can say, like, I'm not a lawyer, but I can read. And it's straightforward about what it says about 504 being unconstitutional. And I appreciate how that's been described here, though, and what that really is getting at. But that's even more concerning when you think about that they are really looking at this final rule. And, the idea that questioning people not being able to access the most integrated setting that they need to be in, whether it's in a community setting, school setting, healthcare setting, and, talking about institutionalization in this lawsuit is like, this is going backwards. We have already other laws in place that are trying to move people into the community and out of institutions. And, just the questioning of that because of budget money, wanting to cut the federal budget and using this as maybe a potential way to get some extra funding it's just unconscionable that we're moving in that direction. But what's been awesome to see is how advocates have come together, started talking about this, as I said early, have sent lots of letters and made lots of phone calls to the Iowa Attorney General's office. I know that she was inundated enough that she had to make a statement to, they put out a news release and then made a statement to the media. And as has been explained here, was not very accurate and had a lot of, lack of a better word, propaganda about their agenda and why that they're pushing this particular lawsuit based on their dislike of gender equity or gender dysphoria language being included in it. And just to be able, just to want to have to, throw the baby out with the bathwater, so to speak, with, what this could do to disability rights it's just incredible to know that could happen.
And I really want listeners to know, and of course I know this because I'm the president of the ARC of Iowa, but home and community-based services were birthed in Iowa because of the advocacy of a parent, a public school educator, Julie Beckett. The very first waiver ever in the nation was called the Katie Beckett waiver. And that is because Katie Beckett was institutionalized for the first 3 years of her life. And Julie was from Cedar Rapids, Iowa, and she advocated to her legislator, asking them to allow Katie to come home because she knew that the care that she would receive in her home would be less expensive and more effective. And that as parent, she should have a voice in the outcome and how her daughter's care is administered. And Julie was a board member for the Arc of Iowa. And Julie would say that we just have to be at the table and that we just need to keep contacting our legislators. And so, to anyone listening, I would tell you to not only contact the Attorney General, but to contact your local House of Representative, contact your senator, do that at the local level, but you also need to reach out at the federal level because this is a large, complex issue that is multifaceted, and it has to do with the vote to defund Medicaid for $880 billion. This has to do with administration of block grants for Medicaid that would only cover the federally mandated institutionalized care, not the home and community-based services that so many people love to refer to as entitlements. And we recently had Zach Meagum on the show and talked about how his ventilator is not an entitlement. His wheelchair is not an entitlement. There are things that are necessary for him to live. And so I think that when we talk about media coverage and trying to really get unbiased media coverage, it's important that we are not just going to our regular standard mainstream media sources, but we are looking to independent journalists like Laura. We are looking to even Tony Lays with KFF Healthcare News, who's done other stories about some of the real crises that are occurring here in our state when it comes to the way that people with disabilities are being able to receive their services and care. Are there any? Yes, please.
I just wanted to mention too, Nancy, that there's one person that you didn't mention as an elected official that we should really turn to now with concern, and that's the governor. This is a lawsuit by the state of Iowa. It's not just by the Attorney General. And the governor leads the state of Iowa, and if she doesn't know, she needs to know that disability advocates are very concerned about this and not very happy at all. So please write the governor's office. We have a Take Action Center on the DD Council's website that you can quickly and easily pen a letter, but we also, or email, and we also encourage people to, share their own stories. And it's, probably a little bit easier. You do have, like Emma has a daughter on a 504 plan, because that part of Section 504 is kind of easy to understand. It's not, most people don't understand what they're going to the doctor's office and being accommodated for something. But that's, some of that is covered because of Section 504. But just to tell your story as a person with a disability, as a parent with a child with a disability, as we talked about earlier, all of these laws are intertwined, and the chiseling away of civil rights is being, viewed in real time. This past week, the Iowa legislature, passed a law to remove gender identity from the Civil Rights Code, and so. If it's going to start there, and we're talking about gender identity, and that's part of this lawsuit, where can it go? If this lawsuit were to go forward, as our other panelists have noted, so we have to keep our voices heard, and it doesn't have to just be to elected officials. Go online on your Facebook pages and talk about how. Talk about your stories and why having rights for people with disabilities is important. And the other thing I wanted to mention too that came out of the legislature this past week that was very troubling is we had a senator who said that we don't need to have protected classes in this country. And that's concerning. I mean, in a perfect world, yeah, that would be great. We would, everybody plays nice, but We know it doesn't work that way. So these laws were put in place for a reason. Disability rights advocates, marched on the U.S. Capitol, climbed the stairs, crawled up the stairs for a reason. 30 some years ago. And, in 1973, when Section 504 was passed, there were reasons for that. And this final rule that is in this, that is being challenged in this lawsuit was passed for a reason just a few years ago. People during the COVID pandemic were discriminated against in healthcare settings because they were disabled. That's part of where the 504 final rule that's being challenged here, part of why that came up. So yeah, it's hard to understand the implications of this lawsuit if you don't have or know somebody with a disability, but we all do. And paying attention just to what's going on and not just dismissing it. I mean, I've seen people who with disabilities make comment online that, oh, this doesn't pertain to me. This is only about the gender identity issue. And that's just dismissing something that, because it's easy to do sometimes, and because there's a lot of misinformation, but dig deeper and talk to people and talk to experts. And please, all of us who work for disability organizations are willing to help and are willing to help you navigate how to talk to people and tell your story to make sure that this lawsuit gets dropped or doesn't go through, or that 504 is maintained.
Thank you. You don't have to have a disability to be an ally. Laura?
I wanted to also second the recommendation of Tony Lay's reporting. He's a really outstanding reporter. But I would encourage people in the disability community to reach out to reporters because, as I mentioned, I learned about this lawsuit on February 10th, but I found out after I published my story that there were people in the disability community who knew about it in October or November. And so a tip is always helpful. I am not an expert in this area, and most reporters aren't. I don't know of any Iowa reporters who are specifically on this beat. So always worth reaching out, even if the reporter might not always have time to follow up immediately on that tip. Really important because I would never have known about it.
That's such great advice. And I think that's really the important message that we want our listeners to take away from today is that in order for these protections to be saved, we all need to take an active part in what's going on. We need to actively work to be informed. We need to actively reach out and show up at these town hall meetings so that we can protect our history and we can protect the rights of people with disabilities. And the DD Council, Disability Rights Iowa, Allies in Advocacy, there are so many amazing groups out there that the Arc of Iowa who will help you know how to tell your story and help you reach out to your legislators so that you can get involved. I just want to thank each and every single one of you for your time today. Your voices being contributed to this story have been so important. This is KHOI, Story City Ames, and you've been listening to I Am Able Iowa. I Am Able Iowa airs the first and last Saturday morning of each month at 9 a.m. on KHOI 89.1. You can also hear us streaming live online at KHOIFM.org. We invite you to share your comments, questions, and program ideas with us. You can contact Doug at thearcofiowa.org. And if you visit www.thearcofiowa.org, you'll find previous episodes and more information about our program. I Am Able Iowa is produced by the Arc of Iowa, headquartered in West Des Moines, Iowa, with local chapters here in Ames and across the state of Iowa. Thank you for listening, and until the next time, this is Nancy Baker Curtis saying, you are able, Iowa.